all the banks are doing that.
Okay, well, I guess we can get started if you'd like, Kathy, if you're ready. We still got some people coming in, but it's 2 minutes after 11.
Okay, and this is Kathy, and I'm going to point the phone. We're working off my iPhone, and Christine and Chris are here also, so I'm going to point the phone to each of them to say hello. Hello. Okay. So we're going to pass the phone back and forth depending on the questions. If it's okay, I would just like to say something preliminarily. You know, this is an unprecedented thing for us, having the courts be virtually shut down for an unknown amount of time, and having, you know, local and national officials just pillory landlords and evictions. Like we have some way to get by, you know, without money, unlike anybody else, right? But there's been some media where another eviction attorney, who represents really what's kind of a well-known giant slumlord, has been very aggressive on in the paper and on TV, talking about they should just pay their damn rent and that kind of thing. And you may have those feelings. You can call me and express them, but we're not going to be expressing those in public to media or to the courts. We think when we are able to get back into court and, you know, process our evictions that way again, you know, I would not be surprised at all if we lose the ability to charge late fees or, you know, that kind of thing. We also think going forward right now, obviously we'd like to still be filing evictions and making money. We can't really get court dates, or at least not court dates that we think are going to hold right now. But there are a couple of advantages to filing now if you need to. One is we will be at the top of the queue when they start processing evictions and handing out court dates again. And the second is, even if it's not processed to give us a case number and a court date, we will have an e-filing number when we file. And we believe that we can prepare and enter consent judgments with that e-filing number. We actually think this is going to work to the benefit of everyone. So if you think you might want to file an eviction and you're in touch with the tenant, we can work with you to draft a consent judgment that they can execute and that we can file, so that when things start back up again, if they haven't been keeping their payment plan, we'll be able to move forward. And we think that it will be viewed favorably that we are working with people and doing payment plans. So that is going to be our suggested strategy going forward. There are some issues with respect to that, with respect to people who have government financed loans on their rental properties. That we believe is in a moratorium right now. We're still learning more about that as we go forward, but we would want you to check that before you decide that you want to go ahead and file. Okay, so what's our first question?
If you got questions, put them in the chat, please.
Oh, I don't see the chat. So will you read them to me?
Yes, absolutely. Yes.
Do I see the chat?
I don't.
I only see two pictures. I see you and I see.
Okay.
It's on the side.
Yeah, if you're on your phone, I'm not sure how that works.
Okay.
We're not exactly technically savvy with this.
No, nobody is right now.
I'm on all these court committees because I'm old, and they feel like I have nothing better to do, right? And I'm on this committee, the Civil Justice Reform Committee, that's been studying, like as recently as our last meeting a few weeks ago, technology in the courts, and we were starting to get ready to make recommendations to the Supreme Court. But this is really fast forwarding that. I'll tell you, we're really on a learning curve. We're on a learning curve like the death rate in Lombardy, Italy. It's just going straight up, all the stuff we're learning every day about technology.
I can imagine.
I don't see a chat window anywhere on my computer.
It's at the bottom.
It's at the bottom. You should, if you put your cursor down, it will open up a bunch of
How are you?
places.
Oh, gotcha.
I can see your names.
I've got everybody muted because of all the background noise that's normally associated here. And we can unmute if somebody has a question, but if they just want to put it in the chats, we can read it to you.
Okay.
That's good. He's muted everybody.
So your suggestion, though, if I understand this right, first get in touch with your tenants, stay in good communication with them. And
Yes.
if they have a problem, like as far as not being able to pay their rent, it's always, and I agree with this 100%, it's always best to work something out with them anyway than start over.
Right.
Okay, here's a question for you. Can we change the locks on a commercial tenant if the lease allows for this? Is there a specific law preventing this for commercial tenants that are in breach of the contract?
If you believe that the person, commercial or residential, is still occupying the space, you should not change the locks. Now, and this is something that, you know, is very situational. So you can call us if you want to talk about a specific situation, and we can tell you our recommendation. We do have another tool that some of you might be familiar with called the Notice of Abandonment. This allows us to post on the property and send regular and certified mail if you have the reasonable belief that the person is gone. And we can do that now. That's not being stopped now. And if we go through that process, it protects you from disposing of the person's stuff. It also means that if the tenant responds within the 10 days and says, no, I'm still in there, that you would have to then wait and go through the regular eviction process when we're able to do that. We charge about $150 to do that. And because it's not through the courts, my older son, who is our special process server, can serve those and post those. And right now I can still go to the post office and do the mail and the certified mail. So the notice of abandonment is something to consider if you reasonably believe that the tenant is gone. And again, we would want to go through each situation to make sure that we were on firm ground there. Chris, did you want to add something?
Yeah, my thought on abandonments during this time frame is to be particularly even more careful than normal because of the stay-at-home orders, particularly in your commercial spaces. You might not have a commercial tenant who comes to their property for the entirety of the time. So you'd really want to be sure like that they looks like they're moving stuff out or anything, or it's you want to be extra careful because I think a lot of judges, if you just go, well, I haven't seen them for a month, that they're going to go, well, that's reasonable because they were stuck at home. And same thing with residences as well.
Okay,
Well, because if they're not an essential business, that they're not allowed to be open, they're not there, they're not going in there, they're not doing anything. I would be very cautious in even doing that without something more than, oh, we just haven't seen them there. Or, I mean, if the place is empty or stuff's cleared out, we've got more than the standard stuff, but this is an odd time that I agree with Chris that we would be a little more cautious on what basis for the actual abandonment.
those are all good points. And some of the things that we often check with respect to abandonment, like are the utilities still on, are not going to be operable now because the utilities are leaving the utilities on. So we're going to want to talk to everybody about those things, but that is an option. And if you think you might have an abandonment situation, call us and we will try to work through that and see if we're eligible for that. Okay.
Okay, here's another one. Will regular tenants not pay hoping for government help, and how much grace period would you recommend?
Well, again, we would recommend trying to work something out with them. I'd said a little while ago that a good strategy might be to get a lawsuit on file, even if we can't get summons issued, so that we can have the e-filing number, and then work out a consent judgment with tenants who are, who are wanting to make a payment plan and that kind of thing. And it may be that some of these tenants will work out a payment plan that involves, getting the government money. At this time of year, we often see tenants curing with their tax returns. I don't know if they've been able to get tax returns filed at this point.
I was just going to say, I think this might be a good time for Chris to talk about the CARES Act, and because under certain covered properties under the CARES Act, a landlord may or may not be able to proceed because of the moratorium placed on a covered property. So that's even more reason to get and communicate with your tenant and see if you can work something out where maybe they're paying partial rent for the first or for the next few months with certain period. But I think we need
Hello.
to try Chris to kind of
Yeah, I'm on a teleconference with the attorney.
property
What's that?
indicate about what you can and can't do versus a landlord that wouldn't be covered under the CARES Act and what you can do. Because there's a difference about what you can do now as far as filing if you're covered or not.
Okay, we're gonna hand it to Chris to give CARES Act information.
Yeah,
All right, guys. So there's two main categories that can qualify your property to be barred under the moratorium. So first, I'll describe what the moratorium is. Under the moratorium, for the next 120 days from the 27th of March, which would be July 25th, you are not allowed, if you're a qualified property, you're not allowed to evict anybody who you haven't already started the process on, meaning file a lawsuit, on the sole basis of non-payment of rent. So that means if I would say the primary basis is non-payment of rent. If they're causing other problems, otherwise violating the lease, threatening you, destroying the property, things you would normally terminate for, you can still terminate and file the unlawful detainer, but you can't do rent and possessions. At the end of the 120-day period, you then have to send a 30-day notice telling them they have to either pay up or move out. So that really brings you all the way out to August the 24th, I believe, because you can't send that notice out until the 120-day period ends. So there's two main categories that qualify you under the moratorium. The first one being that you have a federally backed loan. So you're talking FHA, VA loans. There's a number of different programs, Fannie Mae, Freddie Mac, stuff like that. Typically these are for your bigger properties, but if you happen to have one of those loans, you are under that. And you may want to call your lender to double check and make sure, because the courts are going to be asking about it and the defense attorneys are going to be asking about it. So you're going to have to most likely plead when you file that you are not a federally backed loan during this period. The next big category would be if you are part of a federal program, rent program, like LIHTC, HUD leases, rural rental things, and Section 8 is probably going to be your big one. I would say on Section 8, it's probably going to be a tenant by tenant issue. So, it's not like if you have one Section 8 tenant, your entire building can't do it. But if you, for that particular Section 8 tenant, if for some reason they're not paying their portion, you can't put them out. Not that I'd really advise it at this point, because you want to get as much rent in as possible, but they're going to be qualified. So that's going to be your first step in it, and that will inform, the reason we brought it up now, will inform your decision about how much leeway you give these tenants. I've had some landlords that are reducing rent during this period to try to encourage them to keep paying by, if you keep paying, I'll lower your rent from 600 to 300 or something along those lines. But you can also do like Kathy suggested, for the time being, we're going to accept payments lower, but you have to make up for it later on and things like that. You think I missed anything?
The only other thing would be encouraging and the only other thing I would add to that would be, if you have Section 8 properties, to encourage your tenants to talk to their caseworkers about lowering, if they've lost their jobs and can't pay their portion anymore, or there's been whatever change in income, even if they haven't lost their job, to go talk to the caseworker so that they could show there's a change in income, get their portion of the rent lowered, in which case Section 8 would then pick up a higher portion of the subsidy, if not all of it, where you could still get paid that way. So that's something else, if you have any Section 8 kind of properties, to encourage those tenants to go talk to their caseworkers to put in the paperwork to do that. Oh.
Okay,
All right. Great, thank you. What about, will regular tenants not pay hoping for the government help? And if so, how much grace period would you recommend?
okay, well,
That's a loaded question.
$1 million question.
yeah, there are a lot of tenants running around talking about rent strikes and all this crazy stuff. I mean, I think, I hope that most of us are just going to try to continue to pay our bills as best we can, you know, and hope we get through this quickly, maybe get some government help if we can. But these tenants have to realize that, you know, sooner or later, the so-called chickens are going to come home to roost. I think I might want to pass the phone back to Chris again so that he can make comments about, did you already talk about the government assistance? Okay, to the landlords.
Oh, no, I didn't talk about that.
Yeah, there's some government assistance available for landlords. Honestly, we don't know what tenants will do. You know, we have a practice where we only see the bad tenants. So my immediate reaction is, yes, all these tenants are going to not pay their rent ever all the time, because that's the only tenants that we see. I'm sure you have, I hope you have some good tenants who really try hard, and hopefully they won't do that antisocial behavior. But specific situations, call us. And then I'm going to hand the phone back to Chris so that he can go over some government programs that might be available to help landlords get through this time.
All right, so what Christine's asked me to point out is that the court shutdown at the moment is another thing that might cause you to consider giving more leeway than normal. Typically, I'd tell you they get behind, it's not like they're going to pay, set it over or file yourself, and you're going to be in court in 3-4 weeks, and you can get them pressured. Right now, if you file, we're not getting court dates till the earliest May. My guess, we won't have court dates until June, which means your tenants won't even know unless you tell them that you filed, until we won't have a summons to serve on them until May. So the pressure for them to be put on them by the courts, the immediate pressure isn't there. I would say how much leeway you get depends on whether this is a tenant who has been a problem before or a tenant who's been a good payer up to this point. You know, the ones who you know, they paid every month, paid on time, I'd give them obviously more leeway than the ones who are already 2 months behind. And I've been telling my clients, for the ones that you know you're going to have to put out, regardless of whether or not you think you're going to have to catch up, if you're 6 months behind coming into this, go ahead and get it on file just so we can get in line. But the ones that, you know, that were pretty good, I'd give them some more leeway. The other thing I've been telling them to consider is, if you have somebody who didn't pay, just didn't pay for April, and they paid before, I would make sure, maybe send them a letter, letting them, making sure they understand, because a lot of people think, or I'm hearing about, may think that this moratorium means they're not going to end up owing the rent. So it may be important to remind them, not only that they, you know, while you may be working with them, that they do still owe the rent once this is over, particularly if you're a moratorium property, but also that you're willing to do payment plans, because the ones who are not paying, if they know that there's one available, then they may take you up on that, as opposed to just sticking their head in the sand and holding on to their money until the end of the moratorium or until the courts reopen. So I think it's going to involve a lot more proactive action on behalf of the landlords than you normally would, because normally I'd say, you know, don't waste your time, just go to court. So I'd give them more leeway, particularly if they're contacting you and working with you, then I'd say don't, you know, talk to them and see what you can get done before you just, you know, run to file. But if they're ignoring you or telling you, you know, they curse you out and tell you they're not paying, then maybe the leeway isn't as warranted. I mean, Kathy, you want me to talk about some of the options the landlords have to? Okay, so there, you know, you probably know the CARES Act, you know, while they are stopping, make it harder for the tenants to file, or landlords to file on tenants, they're also giving you some good options to help recoup some of that, either through, if you have a federally backed mortgage, particularly if you are a 1 to 4 family, you can potentially, if you have a forbearance on your loans for mortgage payments for 360 days. So you'll have a lot of leeway there. You have to show some hardship, and I know the banks are changing. They're still trying to learn what you have to prove to get that. But my understanding on it is that you'll be able to, the interest will grow as if you were making your payments and not a penalty interest. So, you know, that's a pretty good option if you have a federally backed mortgage and are barred from that. And even if you don't, I've talked to some of my clients who say they've reached out to their lenders, and the lenders are giving them interest-only payments or reduced payments or their own forbearances. So most of these lenders are being encouraged by the federal banks to be pretty generous. So I would be talking to your lender about that. So that, I mean, that's going to be your big thing. The other option is, you may, because you are technically a small business, all these small business loans, a lot of them are going to be available to you. So even if you don't have employees, there's I know a $10,000 grant loan, there's low interest SBA loans. So those are all things you should be talking to your lender about, because you need to be able to pay, you're gonna have to keep your upkeep on your property and stuff like that you'll be needing to take out money. And, a lot of you, this is your income. So you should be able to get some loans that could help you out there.
Okay,
Thank
what
you.
else we got?
Well, there's a couple of them, they have leases expiring like the end of April or right now, or they wish to terminate the leases. Some of them are behind in rent. How should we proceed with situations like that? Should we wait, or what would you suggest?
Well, again, if they don't move, we're not going to be able to probably evict them for a while. I did have a conversation with a St. Louis County judge who was asking, what do you really need to have happen about like the problem tenants, like the crackheads or the people who are shooting up the parking lot. And I think that, you can imagine there are a few things that the courts are still doing now. And one of them is adult abuse, restraining orders. And I'm sure you can imagine with everybody confined at home, those tempers might even be a little more flaring than they ordinarily would. So we're prepared to talk to the judges and get through bad behavior evictions where people's safety are being threatened. So first of all, call us if you have that. I'm not sure if they're going to be able to accept filings from pro se's, from unrepresented landlords on that, but we'll try to help you if we can and find out about that for you if you want to do it. When their lease is up, as you know, if you don't accept any more money, they are automatically eligible for an unlawful detainer and owing double rent. But again, their lease is up at the end of April. We could probably file suit May 1st, but we're not 100% sure that we would have a court date by then, to be given by then. It's possible if we're going to reopen in June that we could get court dates, by then, but we're just not sure yet. We might need to get back with you guys like every week during this so that we can tell you, because I feel like as soon as we think we know something, the target changes. And I think the other thing that you should consider with respect to, are you going to kick the person out? If they're not paying, then yes, sooner or later you're going to kick them out. We're going to help you. If their lease is up and you want them to go, don't accept, lease is up at the end of April, don't accept May rent, because now you've created a month-to-month tenancy. You might want to have a month-to-month tenancy, which is also terminable on a month's notice, just so that you can get some income until, things start up again. But don't start taking rent from people that you absolutely want out or are problems and that kind of thing. I feel like Christine wants to add something here. So
And my mind just went blank.
her mind went blank. Okay,
I
wait, hang on. I'm giving it to Christine. Her mind's blank.
I think what I was going to add to it was, at this point, we don't know what the courts are going to do. Every county is different, and we don't know if they're going to when they're going to reopen, when they're going to start issuing court dates again. So that's just something else to keep in mind, because we don't know what other restrictions they're going to put on anything. We right now only know they're shut down through April 30th, but it could be extended. And that's why Kathy said, we're going to try and update everyone every week or so, just because things are constantly changing, sometimes on a daily basis. So that's all I wanted to add about that.
So I realize that some of this might not be helpful to the specific questions, but we're just trying to give you as much information as we can. The bottom line on evictions, whether it's the end of the lease or anything else, is we don't know when we're going to be able to get for sure court dates. By the end of April, maybe we'll know. The other thing is, I guess I would consider, if the person's lease is up, do you have a better tenant to replace them?
Mm-hmm. Well, that would kind of go with the question of any advice on showing houses right now if you do have vacancies. Would you proceed with new tenants? Boy,
I think that's really tough. I really want you guys to be safe. I don't know. I'm not a domestic goddess, as they say. I don't know how to sew anything or cook or anything. I know how to practice law. That's my only skill. So I don't know how to sew a mask, but I would definitely be, it looks like they're talking about these particles being aerosolized. So protect yourselves, even with homemade masks, with gloves if you can get them, with, I mean, just protect yourselves on that. I just think you should be really careful. I'm not going to tell you that you can't show houses. I believe that real estate activities are currently exempt from the city and county stay-at-home orders. And I know that there are people who, I'm involved in a situation right now where someone's going to be showing a condo and they've decided to do it by leaving the key, and then the prospective buyers are going to come and go through a loan. Ordinarily, you would never do that, but I think that's the way that's going to be worked out. It's scary times, guys. Just really be safe.
Thank you. Now, as far as do you have any kind of idea about a sample, maybe a payment agreement that you would give to your tenants or somebody to make up, I guess, the difference?
We sort of do. I think that's another thing that's really situational. We would want to, we want to know things like, what's their payment going to be? We would want to include the current monthly rent going forward. We would want to know, are they going to pay weekly, bi-weekly, monthly? I think Chris and Christine both have things on their computer that they've done in the past, and they could, get one together really quickly. And we would want to do it, like I said, if you wanted to file suit, we'd want to do it as in consent judgment form so that we could attach it to a lawsuit and then maybe save you a couple of steps when if you need to execute and bring the sheriff.
They can file.
Well, I think we can still file, and I think we can do this.
Not if you're on a covered property.
I'm sorry.
That's all I'm
Christine's
saying.
reminding us that if you're on one of those covered properties with the government loans, you might not be able to file at all. But still, doing a payment plan could be a good thing. We believe that might be helpful when we're going back into court to say, look, Judge, we already tried to work with these people and they didn't do it, and now we need to move forward.
Okay, now would that also apply to those of us that may not have government-backed loans? Would you
Or
go ahead and
if you
file?
have a back loan, we can file. We can file in the court. We can't really get a court date right now. We can't get summons issued, but we could file in the court, and if we worked out one of these consent judgments, we could file that, and it would be enforceable when the sheriff is ready to start up doing the business of evictions again.
Okay.
And you would have, we believe, the advantage of being towards the top of the line.
Okay. Now, if somebody did want to terminate tenancy with one of their tenants and the rent has already been sent in by mail, would you recommend sending it back by mail, or is there a better way to maybe send it back?
Are we talking about a situation where the lease is up?
Yes, they want to
Okay,
terminate.
so the lease ended March 31st, and they sent April rent?
I believe that would be the situation, yes.
Okay, return the April rent, yeah, if you want them gone no matter what.
Okay.
Okay.
Would you recommend somebody signing a waiver before they looked at a house by themselves, or?
We all have stumped faces on that right now.
Yeah, I don't know.
Yeah, we're not sure we would let a tenant view a property by themselves. Although I have clients who do let them check keys out and go look.
I just wouldn't, I'd just be really careful with that. You don't want any kind of.
We're saying
you're giving them the keys to go look
Right.
at the property, and then they're gonna plant themselves in there.
Right. We have another concern too now. We know that hundreds of incarcerated people have been let free.
Yeah.
And there's people who are probably have some desperation going right now. So that's another reason to be really careful about keys and showing and that kind of thing. Maybe go in pairs, just do the best you can to be safe on that. I don't know about, in Missouri, you can't excuse someone from their negligence in advance. We could probably give you some kind of waiver or release that you could let someone sign if they were going to look at something. I'm not sure how enforceable it would be.
Mm-hmm. Do you think there's any danger on somebody maybe just moving into an empty house?
Yes.
And
Yeah.
what would you think about that? I mean,
yeah. And I'm not really sure what the police would do.
Hmm.
Christine is saying nothing. You know,
Anything when we don't have this
Right.
situation going on. And so I certainly don't think that they're going to do anything more now that we have this.
we think that that enforcement of these kinds of things is going to be even more sketchy during these times.
Mhm.
And that might be the way it has to be. The police might have more important things they have to do, like keeping people out of the parks. I don't know. But
Yes.
yeah, I mean, I would certainly keep your buildings really secure and keep yourselves secure.
Yes. Well, what about
You could
tenants?
try-
maybe-
If someone breaks into your building and squats there, you could try calling the police. Some might help you.
Okay.
Yeah.
And what about tenants that are moving in, friends, and maybe doing some damage to your properties in the meantime? Is there anything to be done with it? Something like that?
Well, I would certainly document it. I would certainly send them, lease violation letter. I mean, I would go forward with that usual process.
Mhm.
But again, we might not be able to do anything about it for the time being. And, if they move them back out once this disruption is over, I don't know that a judge is going to be that sympathetic after the fact. This is even our experienced judges who are used to hearing, BS stories from tenants. This is a different thing. And
Mhm.
we're anticipating that even our most strict judges will be sympathetic to people having hardships during the disruption.
Mhm. Mhm. And I know we're dealing with St. Louis City and County here. Someone just asked about Warren County, but what about some of the surrounding counties? Are they pretty much in the same boat? Or I believe you said every county is acting differently.
Yeah, I don't know that we know anything specifically about Warren County right now. We go there, but not a lot. But I'm going to hand the phone to Chris because I know that he has been in communication with at least Jefferson and St. Charles.
Okay, thank you.
So my understanding is that the courts are all closed for all these things for now. I mean, I could see a scenario where the smaller counties open up sooner than city and county, just because of the smaller docket size. They'll be able to spread people out, possibly not have as many people in the docket, which I know is our big concern once the city and county open up. And one of the reasons you want to get tenants really far behind on the schedule is because once they open up, it's our understanding that they're not going to open up 200, 300 case dockets anymore. It's going to be for a while 30, 40 case dockets maybe. So that's going to mean, the courts may open up in June. You might file and get a court date in August just because of how far out. We just don't know. But back to the question of smaller counties, I heard as recent as yesterday that St. Charles County was still putting out tenants who already had judgments and had defaulted on the judgments. So my client asked me to go ahead and file for the sheriff to see if they in fact are, because he saw a sheriff's notice on the door next to his. So that's going to be on a county by county basis. I know St. Louis City and St. Louis County right now frozen all sheriff's evictions during the stay-at-home, but apparently St. Charles might not be. I don't know yet about Jefferson. I haven't heard anything out there, but we're kind of all in the same boat. I wouldn't expect to be able to file on any of them right now, but you might see some of the smaller counties opening up sooner, depending on how things change. But I mean, things are changing on a daily, weekly basis, like we talked about. You may see individual counties barring evictions further than the government, or more strict than the government. I would not, maybe not Warren County, but St. Louis City and St. Louis County landlords should probably be looking out for that, just because of the nature of our the governments there are going to be a little more restrictive.
There are several entities that can boss us around during these times. And with respect to the courts, there's basically two levels. There's our local courts, and the presiding judges of the local courts has some authority to do what they want in their court. And then the Missouri Supreme Court can issue orders for the statewide courts. And the Missouri Supreme Court has issued some orders about the courts being shut down and that kind of thing. And those orders come out. We have a stack of them already. They come out pretty frequently. But once the Missouri Supreme Court says, okay, individual courts, you can do what you want, then we'll be looking for our individual presiding judges to do things. Then in the non-court area, there's, the county governments like Sam Page and Lyda Cruson and Steve Ellman. And then there's the Missouri governor. My understanding is that the Missouri governor has not made a mandatory statewide stay-at-home order. So I think that means that rural counties could be up and running a lot sooner than us.
Okay. That's about all of the questions I think we have in the chat right here. So basically, we just need to hang in there and try to work with the tenants, is what it sounds like for the most part. And if we do have the problem ones, go ahead and proceed. I guess that's the way we can. There might be another one here.
Okay.
Let's see. Okay, here we go. How about? Okay, I have a property that is a lease to own. The tenants were supposed to pay the rest of the down money of $3,100 once they receive their tax returns, which they have already received. They are using this COVID-19 as an excuse not to pay for it. Any advice? Is it legal for me to ask for proof of lost hours for their job or lost their job?
Well, it's not illegal for you to ask for that. But again, there's a lot of things that are wrong and they shouldn't be happening. But during these times, we're going to have difficulty enforcing them. A thing to try might be, and again, this is situational, depending on how you feel about these people and if they're trustworthy and if they have jobs that they really may have lost, or maybe you see the documentation of that, that you maybe make an amendment to your agreement, stating how they're going to, proceed going forward. I mean, I have to admit, if I were a family with kids and, I got $3,100 in my tax return right now, I don't know if I'd be giving it to my rent to own or using it for groceries. I mean, it might be good to just work out an amendment going forward. But again, it might depend on your relationship with the tenant and how trustworthy you think they are.
Mm-hmm.
Anybody else?
We have a question about, well, this has more to do, I think, with sales than rental, but it says we're hearing a lot about a home sale environment having both parties sign an affidavit they are committed to closing on the sale date to protect the parties should one of them become ill.
Okay. St. Louis Association of Realtors has a COVID-19 rider already. I know. Pardon?
No,
I know they have a COVID-19 rider that agents are being encouraged to attach to sales contracts. And I think that the issue here might be, the buyers might be still ready, willing, and able to close, but is there a point at which title companies will shut down closings? And even prior to that, are you still going to be able to safely do the preliminary steps of home inspections, appraisals, that kind of thing? Again, I think you could, as of today, I think you can still do those things. And I've been told by an agent client of mine that there are inspectors and, all those kinds of people that are still going out and doing things. And the title companies are still doing closings, but that could change. So investigate that rider. I can probably get a copy of it for someone if they want me to email it to them, or if you're a STLR member or an agent, they can get it for you. I was really impressed with how quickly they came up with that rider. And I think I know the lawyer who did it. I think it's Apollo Carey, who's their counsel. And I was very impressed that they got that going right away.
Excellent. And then somebody asked, I think you kind of touched on this a little bit, but how difficult it is for folks to renting to new tenants. And again, I think you said just be safe is the main thing.
Yeah, I would really want you to be safe.
Mm-hmm.
And I mean, these are times when, your screening is going to be really important, because desperate people might resort to fraud to try to get housing or, that kind of thing.
I've also heard that municipalities are giving waivers that are, you may want to check your municipality where they're giving waivers on getting the occupancy permit until after this all calms down. So you may be able to put people in there with an occupancy permit and not worry as much about being targeted by your municipality. But I would, most of them are going to have people in the office, but I'd check into that. So you may be able to get people in there easier. And then, once this all calms down, then get the occupancy permit. You just want to make sure your tenant is, knowledgeable of that, and that, and of that thing, that they're going to acknowledge that they have no occupancy permit, because you don't want them claiming later on that they don't have to pay you rent because of it.
Right. Yeah. As always, I'm going to say, get everything in writing. And if you can have the tenant sign a little statement, as Chris just said, that would be a good way to do it. And if you can get your municipality to provide you something in writing saying, you know, inspections and occupancy permit applications are suspended during this time, you can give people housing and then address that at the end. That would be good to have. Chris is pointing at the phone again. Hang on.
I have one more thought. I had a client call me up yesterday, told me he gave his tenant, reduced their rent from $650 to $300, did it orally. And of course, the next thing the tenant did said, well, I'm moving out in 2 months. You have $600 for my last rent. Now that's my next 2 months rent.
Oh.
So do payment agreements with somebody. Make sure it's conditional. Make sure it's in writing going, it's $300 if you're going to lower it, but only if you pay, and you can't use your deposit for it because, you know, now we're having to decide whether or not to evict this gal, and she's going to try to come in and claim that, you know, that her rent's only $300, even though she decided not to pay it. So, you know, there's no real magic language, but the form that you need us to have, but just make sure you have it in writing. So if push comes to shove in 3-4 months when you get into court, that there's not any sort of discrepancy. They're going to tell you, you lowered the rent for $200, and you're going to tell the court, well, I said they have to catch back up in August. And so you want to make sure it's at least, you know, text message, email, something, if you're not willing to have them sign and save it. And the other thing I would say to talk about is cash for keys is something I'm advising more people to consider for especially your bad tenants who you need to have out of there. But just make sure you get the keys before you give any cash, and that's what I'd talk about.
Okay.
As far as the waivers from inspections or occupancy permits, would that be on the each individual county websites for the municipalities, or would you know?
We are not sure. So yeah, I'd be surfing that web. You know, we have so many municipalities in St. Louis County that we don't know what they're doing. So I would be surfing the web. I would be calling them and getting confirmation. I would be printing out stuff that you see on the web that says they're waived, or getting something in writing from the municipality so that you're covered against some later claim, as Chris said, of I don't have to pay the rent, I didn't have an occupancy permit.
Okay. And somebody just said something about drive-through closings. Yeah, I'd seen something about that the other day, but I think they were already pre-approved.
Yeah.
So I don't know about starting it. Would you recommend starting a new sale, even a lease or something like that, like on a drive-through basis?
Well, again, I'd want to be really careful about getting ID and, you know, that kind of thing. You know, when you're closing on a sale through a title company, they're going to have procedures in place to make sure that ID is checked and notarization is proper and that kind of thing. We don't usually notarize residential leases. So just be careful. I mean, we have, for example, at our office, we have people who are dropping stuff off through our slot in our front door. And so they don't have to actually be face-to-face with a bunch of lawyers. Which, by the way, I can tell you that in the county stay-at-home order from Sam Page, they listed, you know, exempt occupations. And Chris told me, you know, lawyers are exempt. And I said, they're just trying to kill all of us. I don't know that we're that essential.
He might be doing that, right?
Yeah.
Okay. Very good.
And I will also admit to you guys, as much as this is very painful for me personally and financially, I'm kind of relieved that we don't have to go to court right now, because that's, you know, a cesspool of germs and disgusting things and horrible people. And that's just the lawyers, let alone we have to talk to. And I'm not even talking about the judges yet, you know.
Or the landlords, right?
Yeah, the landlords are probably the cleanest ones. We're somewhat happy to be just ensconced in our little offices and, you know, just trying to help people as we can from here for a while anyway.
Okay, well, that seems to be all our questions. Anybody have any other questions right now? I think you've done a great job answering them. I appreciate that.
Thanks. I mean, I feel like this format has actually worked pretty well for us. We wanted to offer to people that you can call us. We'll answer easy questions. We'll just answer them. But if you need a consultation with us, we're going to do a discounted rate of $100 for 30 minutes. You can pay with a credit card. You know, we're happy to do that so that nobody has to be face to face. And we're really pretty happy. We have a big conference room here, big table. If you need to come in, sit at opposite ends of the table and try to help you. Our receptionist daycare for his little boy closed down, so we don't really have a receptionist right now. There are some people answering phones. Our phone number is 314-962-1115. I'm at extension 11, Christine's at extension 13, and Chris is at extension 15. We are not really working the hours that we ordinarily work right now, but we're trying to ensure that one of us will be here at all times in case you have any urgent things or need to talk to us.
We got one more question if you want to answer it real quick.
Oh, sure, of course.
Okay, it's kind of a statement too. There is no reason for a tenant who is laid off to miss their rent payment because they can get from the Fed $600 a week for 4 months, regardless of their previous hourly wage. Can you inform that tenant to go apply for unemployment?
I don't see any reason why you can't give them that suggestion. I mean, do you feel like that's something that's universally known, or some people are so dim that they need to be told? I don't know.
Well, they may not want to pay anyway.
Right.
So, okay. Well, it's been very helpful. Thank you so much, y'all. And if would you be willing to come back and talk at another time?
Absolutely.
would you like
I was thinking maybe we should set this up weekly, every Friday at 11, and we can give you updates.
That would be wonderful if you'd like to do that. I would be happy to set that up.
We'd be happy to do it.
Wonderful. Thank you so
Okay.
much.
Thanks, guys. Bye, everybody. Be careful out there.
Bye. We'll see you soon. Thanks again.
Okay, I thought they were really well.
It was easier than I thought it would be.
Yeah.